All right, sir, you're James Rucker.
Yes, ma'am.
And Mr. Rucker, in cause number 24, DCCR 1348, is charged with violations relating to hazardous waste and it's a third.
Mark Garcia.
The punishment range is that of a third-degree felony in that one, which is between, if you're found guilty, between 2 years and up to 10 years in prison. Do you understand? And then in cause number 24, DCCR 1349, you're charged with theft of property. Which is a state jail felony, and that's from May 18th of 2022. And then what that means is if you get found guilty in that case, the range of punishments between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
In each of these cases, I have plea bargain rejections here with your signature on them and Mr. Galmore's that shows that the district attorney's office has made offers if you wanted to enter a plea of guilty in your cases. In the violation of relating to hazardous waste, they've offered, it looks like, is that a 6?
Oh, no, I didn't put the year, sorry, Judge. It was short.
Talmore.
The deal was for a short term of deferred.
So it's for a deferred probation that would be up to me, and I guess, which is obviously you've gone over with Mr. Galmore, type of probation where you don't have a felony conviction on your record. And then, is it the same in the other case? So you would be, if you wanted to plead guilty, it would be deferred probations in each of those cases with the term and how long that probation is up to me with input from everyone, of course. You have every right to reject those offers and have both of your cases set for trial. I do want to make sure you understand that what your possible consequences are if you go to trial, what your options are if you wanted to enter into those agreements. And do you understand all of that? And do you want to reject those agreements and have your case set, both cases set for trial?
Yes, ma'am.
All right. And is there any reason, I mean, obviously, I can't imagine that the offer would get better. Ms. Malfino?
It's a Mr. Shearer's case, Judge. I don't have any reason to believe that that offer would change. I know they've discussed it for quite some time. I want to
Yes.
make sure it's on the trial docket that he's prepared to read.
So I do typically make sure, unless there is new evidence that comes up that either Mr. Galmore or Mr. Shearer does not know about, or something has changed, I will not accept these plea agreements after today. And so if you change your mind later and want to enter a plea of guilty, it would be to some other plea agreement or open to the court or something like that. Do you understand?
Judge, just for the court's perspective, this case had a restitution in the amount of approximately $100,000. That's been reduced to approximately $13,000 now that those financials have been sorted correctly.
Okay.
I believe this is a situation where it either require trial or it would be dismissed for restitution.
Okay, so not a restitution paid out over probation. Okay, all right, then obviously if that happens before, then the cases get dismissed, and that's another way for them to get off the trial docket, but other than that, we'll let a jury decide. All right, you're free to go. I'll set it on the trial docket. Thank you.
Drayton Rose.
Good morning. Are you James Allen Bruno? And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Bruno, in cause number 24, DCCR 1151, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from April 21st of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 6-year deferred adjudicated probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number
No
one.
objection?
It's admitted. Is there any evidence that Mr. Bruno is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Ms. Malfino?
Judge, he's not from here. I have a little bit of hesitation with his Louisiana history. If he does, in fact, have any, I cannot see any in NCIC, TCIC, but due to the fact that he's not local, of course, defer to the court, but I would appreciate if we could just hold him for those couple of weeks with PSI coming.
Your Honor, the only record I know he has a misdemeanor marijuana charge from way back and no felony history at all.
So where are you going to live when you're released? Where do you live?
I live in Louisiana.
Where in
Lafayette.
Louisiana? Lafayette. So,
In Baton Rouge.
I'm sorry.
He works in Baton Rouge.
Okay, so here's what I'm going to do, Mr. Bruno, based on the nature of your plea. I'm going to reduce your bond in your case to $1,000. Until sentencing, if you make that bond, I am going to require that you wear a GPS monitoring device. And so you'll need to get that taken care of. They'll put it on at the jail. That's just to make sure we know where you are and to make sure you get back here for your sentencing, okay? Once you get on probation, I don't anticipate that you'll have to continue wearing it. That's just a bond condition to make sure, since I lowered that bond, that you have that incentive to come back when you're supposed to, okay? All right. Okay, thank you, sir. You can go back with the bailiff.
Well, Your Honor, also he might tell him if he gets out about...
Oh, yeah, so
I'm sorry.
Mr. Bruno, yeah, thank you. So also, if you make that bond before probation comes to talk to you at the jail, don't go straight to Louisiana, go straight to probation. Okay, you've got to go straight there. She's going to give you some paperwork today that shows you where to go. You've got to do that interview and get that appointment made for that pre-sentence report. If you don't do that, then you run the risk of me not accepting the plea agreement. Things could be worse.
No, I understand.
And then also, if you're arrested for anything, obviously between the time you bond out and if you come back for sentencing, you've been arrested, then you run the risk of me not accepting that agreement. Okay? Thank you, sir. You go back with bailiff. Thank you. Good morning. Are you Latrick Williams? Speak up. And Mr. Williams, it looks like you've got 3 cases, 2 motion to revoke probations, 1 for evading arrest or detention with a vehicle, 1 for theft of a firearm, and then there's a new case that's been indicted for tampering or fabricating physical evidence. And it's my understanding that Ms. Holmes has let me know that your family is going to try to hire an attorney. Is that correct? So are you asking me to reset your case to give your family some time to do that? Okay, so what I will do that. Mr. Williams, I'm sure you have heard, surely, out there by now, that I get copies of these jail incident reports and how you're acting and what you're doing. You think your family knows this when they're going to try to put up some money to go hire you an attorney? Do you think they know how you've been acting out in our jail? Do you? Do you think they know you've been masturbating in front of the correctional officers out at our jail? Do you think that they know that you're telling them to do their job and you're not going to follow their rules? That you're dashing other inmates with your urine, water, and possibly other items? I would guess other items would probably be something more disgusting than what I've already said, that you're walked up and punched someone in the face so hard that they had to go to EMS, had to come get them. You think they know all that? Should I keep going? Because on those motion to revoke your probations, I don't have to accept any agreement that this lawyer or any lawyer talks to that district attorney about. I don't have to accept an agreement. If I find that you violated your probation, I can sentence you anywhere in the range of punishment. That's what happens when you sign up for probation. If you violate, it's up to me. Sometimes I take deals, sometimes I don't. If you're acting like this, it's very unlikely that you're going to come in and some attorney is going to say, come on, let's give him one more chance. He's a good kid. He's got family. That's great that you've got family, but they don't know how you're acting. And obviously, you're not staying home and doing what you're supposed to while you're on probation. They can only do so much to help you, but you got to grow up and help yourself. If you go to trial on that new case and you're found guilty, a jury will hear all of this. So what's happening out there doesn't stay out there. Everybody finds out about it, and all it does is hurt you. Do you understand? So my suggestion is, the next time you're in court, I don't have a packet this thick of things that you've been doing out at the jail. Because your other attorney, whether it's her or they hire somebody, they're going to have to deal with this. And you can ask anybody. This kind of stuff is not going over well anymore in here. Those people are just trying to go do their jobs every day. They're going to work, going home. They've got families. They don't deserve this. Y'all acting like a bunch of heathens out in the jail? I mean, it's ridiculous. Okay? All right, go back with the bailiff. I'll reset the case. Good morning. You're Guillermo Galvin, and this is 24 DCCR 2321. Mr. Galvin is charged with driving while intoxicated, third or more, and what is the announcement?
Judge, this is going to be refiled as a misdemeanor, and it'll have a couple of weeks to get that refile done and the plea set in the misdemeanor court. And once that's done, I'll send the paperwork to Ms. Malfino, and she'll submit a dismissal.
All right, so what I'll do a normal reset. That gives y'all hopefully plenty of time to get that taken care of. If everything works out, you don't have to come back to this court. If for some reason it doesn't happen before the next court date, then we'll just need to come back here and get an update.
Judge, he's provided over the pendency of this case quite a bit of documentation with respect to his attending rehab, having a handheld that he uses 3 times a day, I believe, kind of around his work schedule. I think Johnny's or whomever in error sent another of Mr. Crenshaw's clients with the last name similar to me to confirm all of the negatives on that. So if I could just get that documentation corrected, we'll take care of it and have a date certain.
Okay.
And I
Sounds
did
good.
send the correct documentation to her this morning.
Okay, perfect. Sounds good. All right. Well, we may see you back in 30 days, but hopefully not.
But
Okay.
just to be on the safe side, can we still admonish him that with respect to having that handheld, continuing it until the plea, et cetera?
Yeah, you're still under all the same bond conditions, so make sure you continue to do everything you're supposed to, and then once you take care of that case, you'll have certain conditions of any probation. You'll be required to follow those too.
And at that point, we'll determine whether an interlock or continuing with that
Sure.
handheld will be best.
Okay. Sounds good. Thank you.
Thank you, Judge.
Mr. Kimler, we lost Mr. Kimler and Ms. Holmes. Oh, she's done, huh? Oh, no, we've got a drug test on hers. And then we've got Mr. Gertz and Mr. Kimler. Good morning, you're Seneca McDaniels. And what is the announcement?
Judge, with the court's permission, based on the underlying facts of this case themselves, we have agreed to forfeiture of this weapon. He has brought payment already today. We just need to figure out who to make it out to, and he's going to pay down the hall hopefully in 2 weeks. We can get it into county court through from his home.
So what I'll do is just a normal reset here. That should all hopefully be taken care of. If for some reason that's not taken care of before the court date here, make sure you show up when Ms. Holmes tells you to, okay? Okay, you're free to go. All right, and court. Good morning, are you Charles Newman?
Yes, ma'am.
And Mr. Galmore, will your client waive the formal reading of the indictment?
Will, Your Honor.
Mr. Newman, in cause number 25, DCCR 0545, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from November 22nd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Galmore? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation. And it looks like there's a co-defendant's case that would get dismissed based on this plea, correct?
Yes, Judge. Correct.
Also, do you understand, sir, that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objections.
It's admitted. Is there any evidence that Mr. Newman is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. Okay? We'll see you back at sentencing.
Discovery.
Yes. Mr. Gilmore, you have your discovery. Just a minute. Good morning. You're Christopher Pickens. Good morning, Ms. DeLage.
Good morning. Sorry, Judge.
That's okay. I've got Mr. Pickens here and Mr. Smith in cause numbers 24 DCCR 2275 and 2276. Mr. Pickens' cases are set for trial to begin with jury selection on Monday, September 29th, yeah. And so I know, Ms. DeLage, you had mentioned to my clerk that you were going to file a motion for continuance, but we don't see that. Did you get that filed?
I did. I first received some kind of weird error that said the e-filing system couldn't process it, something I'd never seen before. So then I refiled it in the same envelope. That caused another error. And so then I refiled it again in a new envelope, and I don't have any results from that.
Okay. And what is the, I guess, just let us know, since you're here, what is the purpose or the reason for that motion?
I am on my way to a trial skills training in Austin, and knew that I wouldn't be dressed and available.
No, but for trial's not until the 29th, so can you be ready?
Oh. Yes, I can be ready for the trial on the 29th. I just couldn't be there today.
Gotcha. All right. And has there been any other negotiations or anything like that?
Okay.
And so, Mr. Pickens, you still want to go forward with your trial, is that correct? All right, so what I'll do is number the cases tomorrow after the docket, and your attorney will get that trial order, and she'll let you know when you need to be back on the 29th. Yes, sir. Stay in touch with Ms. DeLage, and that way, if you're at the top of the list, you guys can get together and start, make sure you're prepared, okay?
Yes, ma'am.
Thank you for zooming in, Ms. DeLage. And
No problem. Thank you, Judge.
Thank you. All right, you're free to go, sir. Yeah.
Back in Vegas last night.
Oh, nice. It's hard to feel sorry for you.
That's tough.
Did you? Yeah, I feel zero sorry for you right now, but thanks for sharing.
Negative.
Negative. All right, sir, Ryan Eric January. Speak up, please. And Mr. January in cause number 25 DCCR 0370 was previously in court, entered a plea of guilty to the third-degree felony the state jail felony offense of solicitation of prostitution. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have.
Any additions or corrections?
Nothing but
So I guess I had a question. I did not realize if we do this on all or if but it's showing a requirement to be on the sex offender caseload. But this is not that type of offense. It's not registrable. And so I don't believe that we have been doing those or.
We have.
I'm sorry. Okay. Yeah, I want to rescind that unless there's some reason specifically in this case that there's different you can get with me. Another thing, so I'll take that out of the orders at this time, and then if there's any issues, then we'll make sure everybody knows about it and we'll get back together. The other thing, Mr. January, that is I'm going to order as a condition of your probation is that you get your GED. It is very important to me. It should be important to you. It will help you do better, get better jobs in your life. And so it's going to now be a condition of your probation that you start that process within 30 days of today, okay? So you can talk to probation. They'll let you know how to get started on that. And you need to get started on it, complete it, and that'll be at least a good positive thing that happens out of all of this. So again, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm I'm not going to do that. I'm going to follow the agreement, defer all proceedings, and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of those rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this conviction on your record. And at the end of the probation period, if you successfully complete the probation, the case will actually be dismissed. You'll never have a conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and be sentenced to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she's going to call you up to your desk when she's ready to go over all of your paperwork. Good luck to you, sir. Thank you, Mr. Rennick. Thank you, sir. Good morning. You are Catherine Castillo, and Ms. Castillo has 2 cases. She's assault of a peace officer and then also driving while intoxicated, 3rd or more. And what is the announcement?
Your Honor, we need 30 days. I've received all the discovery. We're going to review the video evidence. I have an offer now. I'm going to relay that to her. We'll meet before we come back, and the case will be disposed of on that day.
Okay, this will be the last for an announcement.
Absolutely.
Ms. Castillo, make sure you get with Mr. Pageant. Now that he has everything, you guys can go over all that discovery, see what your options are, and we'll take care of your case at the next court date.
Yes.
Okay, you're free to go. Thank you.
Thank you, Your
Mr.
Honor.
Pageant.
May I be excused?
Yes. I don't know how that got over there. What did I do?
Her screen. Just grab it and pull it like you do your Zoom, Judge.
Oh,
Pull it to you.
but I'm not even clicking it, and it's just moving.
Sometimes it just does click. Now grab it.
I can't see it over here still.
Don't call me mom.
Wait.
We're not.
Okay. All right, you're Daniel Spencer Ybarra? Yes,
ma'am.
And Mr. Kimler, will your client waive the formal reading of the indictment in each case?
She will, Your Honor.
And it looks like we're going on the entire, all of the,
It's the second hearing.
okay, so Mr. Ybarra, in cause number 24, DCCR 1722, you're charged with the state jail felony offensive theft with previous convictions. That's from April 28th of 2024. The indictment alleges you were previously convicted of theft September 8th of 1999, January 5th of 2000, 2 cases on February 7th of 2007, September 27th of 2010, May 4th of 2011, and then the indictment.
Oh, I'm sorry.
I know, but he's trying to pay attention to me. The indictment further alleges that you were previously convicted of burglary of a vehicle, a 3rd-degree felony, May 19th of 1986, in 2 cases. And then after those were final, you were convicted of delivery of marijuana, a 3rd-degree felony, November 30th of 1987. Also, delivery of marijuana that same date, November 30th of 1987. And after all of those were final, you were convicted of prohibited substance in a correctional facility, a 3rd-degree felony, July 31st of 1999. And after that was final, you were convicted of driving while intoxicated, a 3rd-degree felony, January 5th of 2000. And after that was final, you were convicted of driving while intoxicated, a 3rd-degree felony, October 29th of 2009. And how do you plead to that charge?
And I'll get the volume.
So you're guilty of the offense you're charged with, and are all those priors true?
Yes, ma'am.
And then in cause number 24, DCCR 2289, you're also charged with the state jail felony offense of theft with previous convictions. This is from September 28th of 2024. It alleges all of those same prior offenses, and how do you plead in that charge?
Guilty of everything, Your Honor.
Did you enter your pleas of guilty and true in each of these cases freely and voluntarily?
No, I did.
And because you're guilty, you did what they charged you with?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler?
I did.
And do you fully understand them?
Yes, ma'am, I do.
And do you understand if I follow any agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am, I do.
And it looks like the agreement that you've reached is for a cap of 10 years. The way the allegations and the prior convictions make these for punishment purposes a second-degree felony. The agreement is to cap your punishment at 10 years. Leave it up to me. You have an absolute right to have a jury come in and determine two things. One, if you're guilty or not, and then secondly, to leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do?
Yes, ma'am, it is.
State tenders number one in each case.
Without objection.
It's admitted in each case. And also, sir, do you understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
I do.
And is there any evidence that Mr. Ibarra is not competent?
None of my knowledge, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty and true freely and voluntarily. Find sufficient evidence to find you guilty in each case, but I'm going to reset your cases so that the probation department can do a pre-sentence report, and then we will come back at a later date for sentencing. Anything that you think is important for me to know, get that information to Mr. Kimler and the pre-sentence officer, and then when you come back, they will present it to me on your behalf. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there.
Thanks, Your Honor.
All right, we'll see y'all back at sentencing. Good morning, you're Anthony Williams. And Mr. Williams, this is cause number 24, DCCR 0401. You were previously in court, entered a plea of guilty to evading detention with a motor vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Mr. Smith?
Yes, Judge.
Any additions or corrections?
Nothing to state. No, Your Honor.
All right, then, Mr. Williams, I am going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with that agreement to a term of 10 years in prison, but I'm going to suspend that and place you on probation for 7 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over, and you'll be able to serve that 10-year sentence, while you're out on probation. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, and you could be looking at that 10-year sentence that you were already agreed to. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right? Just have a seat here in the courtroom. Probation will call you when she's ready to go over your paperwork. Good luck to you, sir. Good morning. Are you Reagan Benoit?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment in each case?
He does, Judge.
Mr. Benoit, in cause number 25, DCCR 0880, you're charged with the state jail felony offense of attempt to take a weapon from an officer from June 1st of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 25, DCCR 0881, you're charged with, let's see, are we going on the count one only in that case?
Is that the one we're doing 6 months on?
6 months was on the weapon, it's 2 years on
This is the TDC.
This is the two TDC.
Mhm.
I mean, yes, Judge, we'll abandon that.
Okay, let me pull this up.
So we're doing 6 on attempted.
Yeah, 600 attempted, 2 on assault.
Okay. All right, so in 25 DCCR 0881, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of assault on a security officer from June 1st of 2025, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis? And do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Benoit is not competent?
No objection.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 25 DCCR 0880, find sufficient evidence to find you guilty, and at this time find you guilty of attempt to take a weapon from an officer. Sentence you in accordance with your agreement to a term of 6 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25 DCCR 0881, I'll find sufficient evidence to find you guilty, and at this time find you guilty of assault on a security officer. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to in these cases we'll run concurrently, which means together at the same time. I'm handing you in each of your cases the trial court certifications that shows that these were agreements that I followed, so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. And firearm is, I have to read the whole thing to you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You go back with the bailiff.
Thanks, Judge.
This is Ms. Malfino's case. Aaron Shetley. Good morning, sir. You're Aaron Shetley. And Mr. Shetley, in 24 DCCR 0776, is charged with assault, family violence by impeding breath or circulation. And what is the announcement?
Judge, we just need a reset. We're still going through the discovery in the case. So if we can just have a little bit of time to finish that.
It looks like you guys were hired. Yeah, just hired August 20th, it looks like, so, okay.
For the next topic, for sure. I've already sent him everything. I want to make sure he feels like he's got it.
Okay, I'll just do a normal reset. Mr. Shetley, make sure you stay in touch with your attorneys, and they'll let you know when you need to be back. Y'all can also visit about all the information that they've received and what any options are. All right? Thank you. You're free to go. Thank you, Mr. Walker.
Max, you, Judge?
Yes, sir.